Understanding Federal Rules of Evidence, exception to the hearsay rule. Let's talk about it. All right, hearsay and exceptions to the hearsay. So if you decide that you want to start governing yourself vis-a-vis doing private administrative procedures or establishing your own laws and government and stuff like that, there's certain things that you need to understand if you're going to be interfacing with the public, like what they can accept as evidence. And how they define evidence is Rule 801. It considers hearsay as a statement that the declarant does not make while testifying at a current trial or court. So basically anything that is done outside of a trial or court case is considered hearsay. However, there are some rules against the hearsay also. If a federal statute allows it or a Supreme Court prescription, federal rules of civil procedure, those are things that are allowed also, including proof of service by affidavit. But what we're really going to touch base on is Rule 803. Feel free to pause and read these at your leisure. This is an inclusive list, and we're really going to focus on numbers 1, 6, 8, and 14. Judges know that people lie, cheat, steal, they're corrupt, and this includes police officers. They're people, you know, and that's why everything can be established through 2 or more witnesses or certain protocols and procedures for evidence you have to follow, especially if you're going to be trying to interface it or interject it into public records or procedures or hearings. All right, number 1, hey, crap happens, right? If you're ever in a situation that you think might escalate into a lawful or legal type of scenario, then it's very important to immediately after something happens, write down a statement of facts of what happens. This happened at this time, this happened at this time, because recollection fails over time. So number 1 is very important for this. All right, number 6, this is important if you're going to be establishing your facts. You want to use someone whose duty it is to keep such records, like a notary, or you can use proof of service through affidavit and or through a public transmitting utility office such as a United States Postal Service or UPS or something like that. All right, number 8. Number 8 is, I would say, the most powerful, and this is why custodians at courts do not want to record almost anything that you bring to them, because if you can record something and certify it out, you have basically won the game. So that is why it is very tricky to try to get something recorded, because any public record is basically exception to the hearsay rule, and you can record almost anything. But that's why the custodians and the clerks are very strong and stringent gatekeepers, because they know if you can record something, you have won the game. This is where number 14 kind of piggybacks off of number 8, because if you have an affidavit or you have some type of trust that has been breached, you can make a statement or record something into the county recorder's office and certify it out, and it basically becomes an established fact.
Hello? You don't say. You don't say. You don't say.
Who was it?
He didn't say.